Coming at you with another, what in this one in perspective, these are a number of cases, but it's highlighted that it's two cases in particular that I want to showcase. But I think it's like four cases in one. The first guy, he comes with this malarkey, like, please let me out. I'm going to be sober this time. And according to Judge Simpson, man, you done said this type stuff before. What are you doing? Right? What are you doing? So his attorney, court appointed attorney, is basically saying, okay, my client wants to be free so he can keep his job. And Judge Simpson's like, man, we done heard this story before. This is deja vu. And the second guy, the main case, because there's multiple cases, the second case, the guy is receiving like a fourth degree felony for child abuse, and he comes out with a made up story for what he actually did. So it was a plea in place, and Judge Simpson was going to take the plea, and you just got to watch the case just to see how everything play out. But let's dive into the content. This is Antonio with Team Tiggio. Like, comment, subscribe, and let's dive into the video.
On behalf of the people.
You too.
Joy Gaines, Senior Assistant Public Defender, with and on behalf of.
Pointing at his ear. Can he hear us, or
I can hear you now, Your Honor.
you can hear us? Okay, because we have equipment if you need it.
It'll be okay.
You sure? Okay.
I appreciate it.
Not a problem.
Your Honor, I was unable to reach Mr. Boyd on the phone. I would ask for an adjournment so we could have some additional time to talk.
All right. No objection from the people.
No, do it.
Okay. So,
Probable cause conference, August 22nd, 2024, 9 a.m. Bond will continue.
Thank you.
You're welcome, sir. Court calls case People versus Devin Schiller.
Mr. Sinatra for the people.
Assistant Public Defender Davy Leba on behalf of Mr. Schiller, who is approaching from my right.
Your name, sir?
Devin Matthew Schiller.
Thank you.
Your Honor, with the court's permission, I'd like to request to address bond prior to addressing the PCC. As Mr. Schiller is in custody, his position is whether he would like to waive or continue to adjourn to seek a misdemeanor resolution is dependent on whether he's able to be released.
Okay, go ahead.
Thank you. I would be requesting a release to home confinement with a release to work. Mr. Schiller wants the opportunity to show the court and the people he is able to remain sober while out of custody. He will not commit any more crimes or have any bond violations. He does have an intensive outpatient appointment at Dawn Farm, which he set up through the jail. It is at 9:30 a.m. on Monday. Additionally, he tells me he still has a job available for him at Johnson and Selvio Properties, where he's the maintenance.
Didn't I hear the same bond argument before?
Not for me, Your Honor.
Oh, so it's different from you.
I'm not aware if the argument is identical to one previously turned to this. I certainly apologize if it's redundant, Your Honor.
May I address the court?
May I continue, Your Honor?
Sure, why not?
Thank you, Your Honor. Mr. Schiller is concerned that if he is in jail longer, he'll lose his job. He does understand that if he were to have the privilege of a bond granted, he immediately remanded if testing positive. He does expect to be tested very consistently. Mr. Schiller also likes the court to know that he will be able to post a low cash balance, say 10% privilege, if that were to be granted.
Okay. Is there anything else?
No, Your Honor.
What did you want to tell me, sir? If that's okay with your attorney.
Yeah, I was just gonna let you, like when you said that the same argument has been made, that was when I first came in before I did 3 weeks in jail over this bond violation. It was on the 11th when I was still on bond, when it first got remanded. The drugs are out of my system now, so when I do go drug tests, like they will be negative.
Is there anything in place regarding any type of treatment or
Yes, Your Honor.
support? What?
He has an intensive outpatient appointment with Dawn Farm on Monday.
At 9:30 a.m.
Are they gonna come see him in the jail?
No,
they
Your
will
Honor,
not.
he did set it up through Sarah Stewart at the jail. However, my understanding is he does need to be released in order to attend that appointment.
Any response from the people?
Well, you remember the community corrections report that brought him.
Yes.
Okay, so I would add some additional context. There was a misdemeanor case in 15th District Court, and I put a plea offer together, which was to reduce this felony to a misdemeanor if he pled on the misdemeanor assault and battery case. He didn't want to take that offer. He let that case come up for final settlement conference. Victim wasn't present, case got dismissed. Why I'm pointing that out to you is that it was an assault and battery where the victim called him a crackhead and he hit the victim, right? So this defendant has a history of theft related convictions on his record, including home invasion, FTD. He got HIDAs for those, but he's had misdemeanor retail frauds. He's had controlled substance use case convictions in the past. He has a demonstrated track record of drug use and or theft, which let's use our logical conclusion of why he's stealing things in the first place. I wouldn't stick my neck out for him right now. And I told the public defender yesterday, what mitigation information would you want to share with me for me to consider reducing this felony to a misdemeanor? And I'm not trying to be tough with the public defender, but I want an honest accounting from the defendant about it. So I wouldn't agree to reduce this to a misdemeanor right now. And I definitely would be skeptical about him being released on bond when he was testing positive for fentanyl and really misleading the court about, I believe he was saying it's how long it stays in the body. And he said he had taken it a month previously, or something like that.
I remember.
Right. So I think you know where my position is on this. Okay.
Crystal
Thank
clear.
And I just want to emphasize that Mr. Schiller is eager to have the opportunity to earn a misdemeanor resolution, and he believes he'll be best able to do that if he is released. He's not asking for a personal bond necessarily. He's not asked to be released without conditions. He's asking for a home confinement order with release to work and very frequent drug testing, where if he violates again, he understands he'll be immediately remanded. And that
Like he was this time.
yes, Your Honor, and that he would not have the
Motion for bond
opportunity.
reductions denied.
So
What do you
Your
want
Honor,
to
we'll
do?
waive it this time.
You'll waive?
Yes.
You understand you have a right to a preliminary examination?
Yes,
You understand that by waiving that proceeding, you'll not have that hearing? That at that hearing, the people have to show by probable cause that the offense alleged was committed and that you committed it. You
Yeah.
understand you won't have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
We do.
Preliminary examination having been waived, defendants bound over in a single count.
Thank you, Your Honor. We acknowledge receipt of the information, waive and formal reading and stand mute.
Defendant every way, former reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for
August 12th at 1:30 before Judge Slate Monday.
August 12, 2024, 1:30 before Judge Slay Monday. Bond continued.
Thank you, Your Honor.
Thank you. Yes, sir. Case of the people versus Tyrone Brown. And she's back.
On behalf of
Hello.
Mr. Brown. Alex Parks on behalf of Mr. Brown.
Mr. Brown, state your name, please.
Tyrone Brown.
Thank you.
Your Honor,
My apologies, Your Honor.
we just got into contact with Mr. Brown this morning. He's been hospitalized.
Okay.
We request an adjournment in this matter.
Any objection from the people?
No, Your Honor.
Probable cause conference, August 22nd, 2024, 9 a.m. Bond will continue. Okay, Mr. Brown?
Thank you. Thank you.
All right, be well.
Thank you, Your Honor.
Thank you. Court calls the case of the people versus Ronald Sims.
Burger Counter. I want you to know today's my last day. This is the last
Is
day.
it?
It is. I have to go back to school. So it's the last day you get to do this.
Where? Whoa. What?
It's the last time you have to hear me read that little card now that I've memorized and be like, oh, here she is.
Like I'm doing something to her. I would just grant her ability to practice, always smile at her, listen to her argument.
I appreciate that.
Kind of hostile. Go ahead.
Thank you, Your Honor. Please state your name. for the record.
Ronald Sims. Sir, thank you.
Your Honor, today we are here to waive exams.
You hurt my feelings.
I'm sorry.
No, it's okay. It's okay. I won't hold that against you.
Hopefully I'll be back next
Will I?
summer.
What?
Hopefully I'll be back next summer.
Yeah, quit threatening. All right. Mr. Sims, you're waiving your right to a preliminary examination?
Yes, Your Honor.
All right, you understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
I do.
And you understand that you'll not have that hearing, you'll proceed to circuit court for further resolution.
Absolutely. Yes, Your Honor.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over at circuit court on a single count.
Thank you, Your Honor.
Okay, it's your turn. You need to do more.
Me?
No.
Yes, I am ready. We acknowledge the receipt of the information, we waive the formal reading, and we stand mute as to the charges.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 20th at 1:30 before Judge Conlon.
August 20th, 2024, 1:30 before Judge Conlon. You notice how she didn't say thank you for your patience.
Thank you for your patience and all your understanding.
All right, you're welcome. Thank you. Bond continued. Who's your supervisor?
Mr. Bellinger.
Okay, now I understand. All right, court calls case, People versus Sean Carlson.
Mr. Club Senator John, if you leave on behalf of Mr. Carlson, voting for my right.
Today is the next date set for a couple of cost companies. We have reached a plea agreement, and that form should have been tendered to Your Honor and to defense counsel.
I do have it. The form indicates that the defendant will be pleading guilty to child abuse, 4th degree, punishable by up to 1 year, up to 5 years probation. And upon a successful plea to that charge, count 1 would be dismissed. There is no other agreement.
That is correct, Your Honor. Awesome.
John Matthew Carlson.
Has he signed an advice or rights form, counsel?
Not to my knowledge, Your Honor. I can have him sign one right now.
Attorney without a pen.
Your Honor, that has been a frequent occurrence for me, unfortunately. Thank you.
You know, that's why they made pockets. You can solve that.
It's absolutely true.
Man. Have the defendant sworn, please.
Raise your right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be God. State your name.
Sean Matthew Carlson.
Sir, it is this court's understanding that you're going to plead guilty to the charge of child abuse, 4th degree. That is a misdemeanor punishable by up to 1 year incarceration and up to 5 years probation. Is there a maximum fine on that? Ms. Reiser.
I don't believe so. Let me check. One year or probation for up to
5 years, no max.
1 year.
All right.
Jail or probation up to 5 years, no monetary.
Gotcha. All right, you understand that, sir?
Yes, sir.
All right. And you also understand that pleading guilty in this case, that I would not be your sentencing judge and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right, understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You had signed an advice of rights form today, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
You'll see it on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will
Yes, Your Honor.
and because you believe that you're guilty of this offense?
Yes, Your Honor.
February 20th, 2024, at the location of 3137 Homestead Commons, Apartment 5, Ann Arbor City, Washtenaw County, State of Michigan. Did you have care or custody of a minor child?
Yes, Your Honor.
And what did you do with reference to that child?
I hit him in the arm with a closed fist.
All right. How old was the child?
10 years old at the time.
All right. And in doing so, you were doing something in excess of discipline?
Yes, Your Honor.
And that did, you would admit, cause physical harm to that child?
Yes, Your Honor.
I'm sorry, I didn't hear the initial factual basis for the plea.
Which part?
What did he say he did to the child?
He said he hit the child with a closed fist in the arm.
Okay, so if I could just read and make sure that this is correct for the record, the police report, Sean approached Anthony, the minor child, and punched him with a closed fist in his face, causing his head to snap against the wall. Is that correct, sir? Did that happen?
That's not what happened.
Okay, there's a big difference between the arm and the face.
Yes, Your Honor, I do believe it's a sufficient factual basis, however.
Was his nose bleeding when the police arrived, sir?
No.
Your Honor, would the court accept a no contest plea?
I don't know if the deal was contingent upon him pleading guilty, but obviously we have two very, very different versions of what happened. I mean, either the child got hit in the face or the arm, and either the child was bleeding or he wasn't. Do this. Why don't I pass the matter? Counsel, why don't you talk to your client?
Yes, Your Honor.
And then I'll call you guys back up and let's see what we can do.
Thank you, Your Honor.
Thank you. It's not, do I have an in custody? They're already on an income. Do I have an in? This is. Court calls the case of the people versus Bosie Smith.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Smith, who appears to my right. We please state your name for the record.
Boise Smith.
Thank you. Your Honor, today is the date and time set for a probable cause conference. At this time, we would like to request a preliminary examination. We have received discovery. We have went over it with my client, and at this time, he would like to schedule that exam.
People have their witnesses available on the 13th.
We will do our best, Your Honor.
Preliminary examination in person will be set August 13th, 2024, 9 a.m. That is before me. Sit at 9 or 1.
Oh, I'm sorry, that's it. Wow.
At 12 noon before me.
And Your Honor, may I address bond?
You may.
Your Honor, as we all know, the purposes of bond is one, for the protection of the community, and my client returns to court. He will do so. He understands that he has that next date of August 13th at noon in front of Your Honor here. Your Honor, his bond currently is set at 100,000 cash surety. It's an unaffordable bond for him. He is not able to post that. Your Honor, I am asking that you consider a personal bond with a GPS tether. I think that This is an isolated event and allegations with an isolated person. So I don't believe the community at large is in danger. So I think a GPS tether, which is a little bit of a less restrictive means than 100,000 cash rate that's unable to be posted, would suffice. And I'd ask your honor to consider that.
Response.
Judge just got out of parole in 2020 for a homicide charge. This involves strangulation. He was strangling her and said, "Bitch, I'm gonna kill you." He hit her multiple times. He's also contacted her while in jail or contacted the phone number that we have 31 times. So I would ask you to keep promising.
Anything else, Ms. Wright?
Your Honor, just briefly, the parole was a juvenile case, and as it relates to the allegations of strangulation, I have seen that. I've also seen discovery. I've seen pictures in the discovery where there is zero redness anywhere on a neck that was seen just.
Were there
after
children
falling.
present at this alleged?
That's what the allegations I see that were that the children I think were either there or she took them from the location.
Motion for boundary reductions denied.
Thank you so much.
Bond will continue. Court calls case People versus Aaron Daniels.
Good morning, Your Honor. Matt, Assistant Public Defender, with and on behalf of Mr. Daniels, who appears today via Zoom. Aaron, can you state your name for the record, please?
Aaron, thanks.
Thank you, Mr. Daniels. Your Honor, today's the date and time set for a probable cause conference. We would like to set both matters for exams, please.
Discovery complete in each case?
To my knowledge, yes, on both.
People have their witnesses available on the 13th. Preliminary examination in person in each of these cases, August 13th, 2024, 9 a.m. That is before Judge Washington on both matters.
Thanks, Your Honor. Thanks, Mr. Daniels.
Continued.
Thank you.
Bless you. Court calls the case People versus Samira Smith.
All right, thank you for looking at this, these cases, several cases. And don't abuse kids. And if you do, get help. And don't lie about the abuse that you did to kid, have done to a child. I put up a video today where our 3-year-old autistic child was found dead because the mother needed a break. She thought she was taking the child to a friend's house, and she never saw her child alive again because she needed that break. Now, I'm not telling you that you shouldn't need a break, but my mom had 7 kids, and my mom never said she needed a break. She just said go play, and she went in the room and watched TV. But everybody's for everybody. But put it in the comments. How do you feel about this case? The guy straight up lied. You can't pull a wool over justice some eyes. He's seen tons of cases, but he don't forget. He's like a night hawk. You know, he's like hovering in the sky. He don't forget anything that you tell him. But like I said again, thank you for all my new subscribers. We're on the road of growing this channel. So hit that notification bell after you subscribe to the channel, and you can support the channel through Cash App, Super Chat,